So I've broken this down into several parts. We will begin with the origins of and evolution of advocacy as a profession. Then we'll look at the history of the profession and its regulation and licensing in the subcontinent. We'll take a look at the current framework in Pakistan. Then we'll move on to what I feel are the necessary traits, skills which are required in the profession in order to succeed. Next, we'll look at stages of advocacy, and then finally, advocacy in practice. There'll be a question and answer session at the end. So if any questions pop into your mind during the presentation, during the workshop, just note them down and send them in at the end. Zarak, who is co-hosting the workshop, he'll note these and put these to me at the end of the session. With that, I think we should begin. I hope everyone can see this. Zarek, can everyone hear me?
Yeah, everyone can hear you, and the presentation is visible as well.
Okay. Wait one second. I just have to close the dialog box and I'll start with the presentation. Okay, so coming to the first part, the origin and evolution of advocacy. So E.W. Timberlake, in his 1992 paper titled Origins and Development of Advocacy as a Profession, he noted that advocacy or some form of it was being practiced long before the practice was given a formal name or was recognized as a profession. Documented origins of advocacy, they can be traced back to ancient Greece. In those times, there were no formal courts, but like cases were heard, matters were sent to the kings, to the rulers, and the people who were on trial or people who were accused of something or defending something, they used to place their case before able writers or orators, and then they would prepare a speech or a narration for them, which the person would go and go to the trial and read or deliver in order to like influence the outcome. This is the like how advocacy was in that time and how it was practiced without having like a formal recognition as a profession. Then during the period of the Roman Republic, there was the concept of a patron, and the patron was something akin to the modern barrister. The patron would also appear on behalf of the client and represent him at trial and like argue his case and defend the cause. But like patron, it was still not a profession in the sense that there was no regulation as to who could become a patron and like what the duties or what the scope of services would be in that sense. And later, after the Republic came, when the Roman Empire was in its heyday, this patron was gradually replaced by an advocatus. Like the advocatus was a group of people like who were somewhat regulated by statute, and their qualifications and duties and compensation and the provision of their services, like they were sort of regulated. So we could say that the advocatus was in some ways the first time that advocacy was as a profession was recognized. And it is not surprising that the word advocatus is in some form now part of what you call this profession in almost every language, including our own. Moving on to, sorry, one second. So the next we look at the rise of advocacy in England. So Maitland and Montague, in their book called The Sketch of English Legal History, they trace the origins of advocacy in England, and they note that a professional class of legists and decretists, and they held themselves out as willing to plead the causes of those who were willing to pay their fees. At this point, laymen used to train themselves specifically for this purpose, for performing duties of advocate. And in the sense, advocacy in this sense became sort of a restricted profession. You had to train for it. It wasn't open to everyone as it was previously. This was the first time that it was recognized that probably some training would be needed in order to carry out the function expected of advocates. Around the beginning of the 14th century, inns of courts, which we all know, were found, and they had exclusive powers to call to the bar and to prescribe qualifications of advocates. And these advocates pleaded for their clients. The inns of courts, as we all know, are the Lincoln's Inn, the Middle Temple, Inner Temple, and Gray's Inn. They also used to exist 10 chancery inns, which they were basically preparatory schools for young students, or they were for the apprentices of the inns of courts. Like they fizzled out during the 18th century, around the middle of the 18th century. In modern day England, there's two divisions of lawyers. There's the barrister and the solicitor. The solicitors also have their own separate origins, distinct from those of the barristers. And the solicitors are basically derived from the people who used to represent the client's person and intent to his cause outside of court. So they were known as the proctor, and it is quite plausible that the proctor was the precursor to the solicitor. This is as opposed to the barristers who actually go and plead on behalf of the client in court. Now coming to advocacy in Pakistan, and just like tracing the origin, advocacy in the subcontinent predates the British colonial era, but it was not a formal profession, and there were no uniform rules and practices which had to be followed. In this context, there were people known as vakils, who were recognized by the courts of the Nawabs. Vakil, as you know, the origins of this word are Arabic, and they've been now been incorporated into both Urdu and Hindi, and it literally meant agents. So vakils were there who you could approach in order to have your case pled before the court of the Nawabs. As a profession, though, legal advocacy was introduced by the British to the subcontinent during the colonial time. And if we were to trace the history of how advocacy as a profession was introduced, for the first time, it was through the introduction of the Charter of 1726, whereby mayors' courts were formed. These mayor courts derived their power from the British Crown, and they were formed in 3 presidency towns for hearing civil cases. Presidency towns were where the East India Company had their headquarters. They were Bombay, Kolkata, and Madras at that time. Criminal jurisdiction, criminal matters were left with the governor, but there was still no concept of any legal training at that time. As Dr. K. Rai, in his book Legal Ethics, Accountability for Lawyers in Bar Bench Relations, has pointed out, the Charter of 1774, issued in pursuance of the Regulation Act in 1773, was the first time when the Supreme Court of Judicature was established at Kolkata, and following that in Madras in 1781 and Bombay in 1823. And that was the first time that the Supreme Court or the judiciary was empowered to approve and enroll advocates and attorneys. Advocates were barristers, attorneys were solicitors, and the charter made it clear that no person other than advocates and attorneys so admitted and enrolled could appear and plead or act in the Supreme Court. It may be pointed out that the term advocate, as it was used in this statute, only extended to English and Irish barristers and members of the Faculty of Advocates in Scotland, and the term attorneys only meant British attorneys or British and Irish attorneys or solicitors. So, as with all bureaucratic executive and you could say spheres of influence at that time, the natives were excluded from the scope of legal practitioners as well. The two grades of legal practice, the advocates and attorneys, became distinct, and they perform roles similar to the one that barristers and solicitors did and do in England. Moving on. So outside the mayor's courts, outside the towns where the mayor's courts were established, those were known as Mufassal towns outside the three East India capitals, East India Company capitals. And advocacy there was still practiced in the same way as was in before the time of the British. It was unregulated and uncontrolled, and all the vakils who used to appear before that time continued doing so. Vakils were usually either untrained relatives or servants of the parties appearing in court, or they were professional pleaders who were training in either Hindu or Muslim personal law. The Bengal Regulation 1793 was the first time when regular legal professionals were also considered for the company's courts. And it was felt that these people who had education, character, and were versed in this personal law of the Muslims and the Hindus, and also in the regulations passed by the British government, would be admitted to plead before the courts, formally established by the Crown. And they would be subject to rules and restrictions sure that they discharged their work diligently and faithfully, and they upheld the client's trust. After that, we had the Bengal Regulations of 1814, which also made certain provisions to the legal profession. It was, however, by way of the Bengal Regulations 1833, which modified the earlier regulations, that any qualified person of whatever nationality or religion could be enrolled as a pleader of the Siddhar Diwani Adalat. So that meant the restriction, which was placed in the sense that only Hindus or Muslims could be admitted as advocates, was removed in 1833. So then came the other law, other landmark law, I would say, the Legal Practitioners Act of 1846. It gave recognition the courts that were subordinate to the Sadr courts, present courts, and it authorized the attorneys and advocates of the Supreme Court, which we learned earlier were primarily British at this time, to plead in the company's courts, subordinate courts as they were. The shift in the barriers to entry of this profession was pursuant to the Indian High Court Act of 1861, and by way of this act, high courts were established in Bombay, Kolkata, and Madras. and they were designed to unify the legal system and to unify the court system that existed at the time. So the Supreme Court and the Southern Court traditions were unified by the high courts, and legal learning, local laws, customs, usages, the judicial experience of the English laws, they were all sort of unified by the passing of this act. And the high courts were given powers to make rules for the qualification of proper persons, including advocates, wakils, and attorneys at bar. And this was the first time that wakils, or like previously previously unregulated advocates were allowed to like join the profession and plead before the high courts. Additional high courts were also, so this admission of the wakils to practice before the high court, it ended the monopoly that the barristers and the attorneys had enjoyed in the Supreme Court previously, and now the Indians could, like the natives, could also benefit from the court system and the profession. Following under this act, other high courts were also formed in different areas, including at Allahabad in 1886, and Patna in 1916, and finally at Lahore in 1919. At that time, there were 6 grades of legal practitioners, I would say. There were advocates, there were attorneys, there were wakils of high courts, there were pleaders, there were mukhtars and revenue agents. So we know about the advocates and the attorneys and the wakils. Pleaders were literally people who could go and plead the case of the client, and mukhtar literally means chosen. So they usually refer to head of a village or a neighborhood. Revenue agents is an interesting one. It gives an idea as to type of litigation which was dominant, and that remains the case till this day. And a lot of the cases do pertain to revenue, land revenue, and demarcation and agricultural land. So the Legal Practitioners Act 1879 was a landmark act in the sense that it brought all the 6 grades of the profession which had earlier existed in different systems under one system, under the jurisdiction of the High Court. And it was the first time that women were admitted into the profession, because it made discrimination on the basis of gender. It outlawed that discrimination. So till that time, it is important to note that the courts were in charge of regulation of the profession. But in 1926, the lawyers felt that they should be the ones who should regulate the profession and not the bench. That resulted in passing of the Indian Bar Councils Act in 1926, where the various grades of legal practice were unified and self-government to the bars was provided. And the bar councils had to decide matters which concerned legal education, qualification for enrollment, discipline, control of the profession. These were the laws which existed at the time of independence in 1947. After independence, the first law that Pakistan made to this effect was the Legal Practitioners and Bar Councils Act of 1965. That was later repealed by the 1973 Act of the same name. And till this day, the regulation of the legal profession remains a federal subject as per the Constitution of 1973 under entry 11 of Part 2 of the 4th Schedule to the Constitution. Now we just move on to the current framework of the profession in Pakistan. And it is very important to understand this frameworks because it gives an idea as to who can and cannot become an advocate. And once you do become an advocate, how are you supposed to go about the profession? First, we look at the Act, the Legal Practitioners and Bar Councils Act of 1973, rules drafted under this act, the 1976 rules and this act together, they are currently the law which regulate and govern legal profession and legal advocacy in Pakistan. Chapter 6 of that act relates to advocate and enrollment and right to practice, and other things such as seniority and pre-audience. So what is significant is section 22(1) of this act. It reads that no person shall be entitled to practice the profession of law unless he is an advocate. So this is significant because all the people who could have practiced law, the profession of law, without being getting the license, this was no longer the case. You had to become an advocate as provided under the act. And what is to be noticed furthermore is that all lawyers, all classes of lawyers, no matter what type of work they do, were unified under that title, advocate. So now an advocate can do the work a solicitor does, or a barrister does, or a pleader does. And as things stand, there is no distinction between the separate classes of lawyers in Pakistan, as opposed to, say, in the United Kingdom. Minimum qualification has also been provided in the Act under Section 26. Some of the qualifications are that the person must be a citizen of Pakistan, which is sort of a restrictive barrier, because I don't think it exists in many other jurisdictions who welcome citizens of other countries to also join the profession, granted that they clear they meet their qualification standards. Other requirements are that the person must be a minimum of 21 years old. So there's an age barrier as well. The person must have a bachelor degree in law from a recognized university or college. Newly added clause inserts that they must have cleared a test set by the federal government. And then there's also a requirement to have undergone course of training and passed examinations after the training as may be prescribed by the Bar Council. So this is why after the law, before getting into the law colleges, you have to take a federal test now, which is set by the HEC. And then after graduating, you have to work for 6 months with a lawyer and then take an exam set by the bar to become a lawyer, to get your license. So the division of advocates in Pakistan isn't about what they do. It is on another basis. They have been divided into 4 classes now under Section 21 of the Act. The classes are Senior Advocate Supreme Court, Advocate Supreme Court, Advocate High Court, and Advocate. Interestingly, though this Act has unified all of the different classes of advocates or lawyers into that single title of an advocate, movement to the upper classes. For example, if you are an advocate and you want to become an advocate high court, or if an advocate high court wants to become an advocate Supreme Court. So all of that are now related to the pleader or the in-court element of advocacy alone. You have to have 2 years experience to become an advocate high court, and then you have to have certain reported judgments and appearance in courts to get to the next step, which is the Advocate Supreme Court. And this is despite the fact that legal professionals in Pakistan, although they're all required to be advocates, are undertaking work which is much vast than just pleading. Transactional work is taken into account in considering if an advocate should transition to the next class. So it's possible that a person who is the best corporate lawyer in Pakistan, would not even be an advocate High Court or an advocate Supreme Court. So this is a bit of an anomaly in the law, that it only takes into consideration the in-court aspect while also unifying all classes of lawyers into a single name of advocate. Next, we move on to the legal practitioners and bar council rules, which have been framed under the act referred to above, and these are the rules of the game. That once you become an advocate, how do you go about the profession? What are the outer limits that you must stay in and confine yourself in? And it's unfortunate that not only are these not really adhered to as much, but like the knowledge that these rules exist is also not very widespread. So chapter 12 of the rules deals with the canons of professional conduct and etiquettes of advocates, and it is further subdivided into 4 parts. The first part is conduct with regards to other advocates, then they deal with the conduct with regards to clients, then there's the duty to the court, and lastly, conduct with regard to the public generally. We'll just like go through the rules. I'll take this opportunity of this workshop to just bring to your notice very briefly as to what these rules are, because anyone who wishes to practice as an advocate in Pakistan must know these and must conform to these. So like 134, it's pretty standard. 135 says that an advocate should not advertise. 136 says it should not employ any other person to solicit or obtain employment for him. It also says that nor shall he share with an unlicensed person any compensation arising out of professional employment, nor shall he aid or abet an unlicensed person to practice law or to receive compensation thereof. So they've catered for the Harvey Specter micro situation as well, and it is illegal in Pakistan too. 137 says an advocate shall not communicate about the subject of controversy with a party represented by an advocate in the absence and without consent of such advocate. This unfortunately gets ignored a lot. And you see lawyers arguing in conversation directly with parties who are represented by other advocates. 138 is also something which is very prevalent, because it says that lawyers should not argue matters in the absence of the other counsel except in open court. But we see this practice so much more now that judges call you into their chambers to argue a case, and you do so without the other advocate present. And it just casts doubt on the whole system and should be avoided. 144 reminds us that clients are the litigants, not the advocates, and we should always try to be professional and above board with each other. Division of fee, it tells us not to have any other basis of division of fee other than the principle of division of work. 145. Now, moving on to the next part, which is conduct with regard to the clients. 145 says you should not acquire an interest adverse to a client in the property or interest involved in the case. 146 says that you should not accept employment adverse to a client or former client, which in any case compromises any information that you obtain from them during your course of engagement with them. 148 is pretty straightforward and it goes without saying that the advocate should not represent conflicting interests. 149 says you should not participate in auction proceedings related to the case of your party, or should not accept remuneration as a reward or bounty. I think this is also very sensible, because if if they do accept remuneration as a walrus bounty, the personal stake of the advocate becomes involved, and it's it's not allowed as per the rules. 150 similarly says that the commingling of property with the client should not happen. Moving on, 152 is important, which says an advocate in his professional capacity shall not advise the violation of any law. This rule will not apply to advice given in good faith that the law is invalid. On this rule, I would say it is not followed very much in Pakistan, unfortunately, which is part of the predicament that we face. Like, it contributes to that largely, and in good faith, no violation should ever be advised. That is a simple and basic tenet that we should all follow. 153 says that regardless of personal opinion, you can undertake the defense of a person accused of a crime. 154 says it regulates fixing fees. It's quite vague, but like one line that I would want to read to you is the last line of this rule, which says in fixing fees, it should never be forgotten that the profession is a branch of the administration of justice and not a mere money-making trade. This is something to be kept in mind as well. Although it relates to very few people in this profession, because most of the lawyers are not in the position to overcharge their clients. 156 says basically enjoins upon advocates to not set up false claims or set up untenable defenses or enable questionable transactions, and it is improper to assert the personal belief of the client's innocence in the course of his duties, and then it lays down a lot of other pretty basic, I would say, guidelines, which like prohibits any sort of advice which would lead to a violation of the law, and that the lawyer should the lawyer should obey the voice of his own conscience rather than that of the client. Next, we move on to the advocate's duty to the court. This is also an important section, important chapter. 159 tells us to maintain towards the court respectful attitude for the sake of the sanctity of the judicial office, while also telling us that proper ground for complaint against judicial officers should not be ignored. 160 should not advise people to not come to court or to conceal himself where the testimony of a person is relevant and would further the administration of justice. 161 also talks about something that does happen, in the sense that it says you should not intentionally misquote judges or judicial officers or arguments of the opposing counsel or contents of the document, or misquote language of books, statutes, or laws. But this happens sometimes, which is very unprofessional and misleading. I've seen lawyers stand on the bar and just say, make up citations, which once you go there and look them up, you won't be able to find. Can we just pause it for a bit? Zarek, can you hear me?
Yeah, I can hear you.
Yeah. How do we stop these participants from like writing on the screen?
Okay, let me just figure that out. Just one second.
Figure it out, because I don't know who this is. You can either remove those people or like.
I think they won't be able to now.
All right, thank you. Moving on. 163 talks about the duty of a person engaged in prosecution, and it makes it clear that the primary duty is not to convict but to see that justice is done. Next up, it talks about the conduct of advocates with regard to the public generally. 160, 168. Sorry, Zed, would you try
Just give me a moment. I'll just figure this out 1 second.
Yeah, sure. Take your time. Zed, could you please let me know when I'm good to go?
Yeah, just 1 moment, please. I'll let you know.
Sure. Yeah. Thank you. Sorry for the delay. Some technical issues. So we were now looking at the conduct of advocates with regard to the public. 168 says you should not accept a case if the sole motive is to harass a person. 169 lays down the duties of advocates in treating adverse witnesses and parties. There should be no improper speech. There should be no personal attacks, and you should not speak what your clients want you to say to them. 170 says, if in your estimation, a defense or a case is merely intended to harass or injure the opposite party, you must decline that case. And in my estimation, our inflow of cases would reduce substantially if advocates actually start doing this. Next, we move on to 175A, which says 175 A and B, basically, which provide for the fact that violations of these canons of professional conduct and etiquette are instances of professional misconduct, and he's liable for disciplinary action in these circumstances. Complaints are sometimes sent by the clients to the bar councils, but unfortunately, because it is a self-regulating profession. Can you? Yeah. Can you go to the previous slide? Sorry for the hold up. That's fine. Sorry. So, Zarek,
Yeah.
can you please play the slideshow? I think it's being hid by the Zoom icon.
Can
Oh,
I?
okay. Never mind. Never mind.
Okay.
I've found it. So as I was saying, कि although professional misconduct के ज़िम्मे में आता है, it falls within the definition of professional misconduct, violation of these rules. These rules aren't really enforced because of the fact that uh, it is a self-regulating profession. Lawyers are adjudicating other lawyers, and they don't want to upset the other lawyers. So like they go easy on them, which is not the best thing to do, but it happens. Or next we move on to the third part of the presentation, which I believe are the necessary traits and skills which are required of an advocate if he is to excel in the profession. The first of them is legal acumen and command of languages. The profession or an advocate deals exclusively with words. So the command of languages becomes imperative. It doesn't matter if it's reading, writing, or speaking, you should be excellent in all three facets of language and have proper command over languages. For Pakistan, the official language of the courts are English and are Urdu. Uh, so you must have good command over both these languages. English, because all of our statutes and judgments are in English. So the original text is always preferred over the translated text, and the statutes as they exist in English would give you a more fair idea of what the law says. So having good English is advantageous to an advocate, obviously. Most of the laws and judgments are in English, but in lower courts, sorry, 1 second, we just got Thank you. Sorry for the technical hiccups. Just trying to play on our Sorry for that. So as I was saying that while most of the laws and judgments are in English, in lower courts and in day-to-day proceedings of the lower courts, court orders are in Urdu, and in many instances, evidence is also recorded in Urdu. Other than that, in criminal litigation or more so, all the complaints and FIRs, they are in Urdu, and so are all the zimmis and then the investigation reports. So, and this is not like typed Urdu, this is handwritten Urdu where you could barely make out what they're writing. It's very important to have good command over Urdu as well. This was, I confess, one of my weaknesses, that I was unable to read handwritten Urdu as well as I would have liked. But then I worked on it, and now I think it's adequate. Like, it's very important to have command over both languages. That is the point that I'm trying to make if you want to be successful as an advocate in Pakistan. The point which needs further elaboration is that merely having good command over languages is not useful in itself unless it is coupled with the legal knowledge and legal acumen. So what I've seen is a lot of lawyers who have good language skills, either in oration or written, they just focus more on the language and less on the law. That is never advisable. You should always ensure that, keep in mind actually that language is just a tool to convey your legal message. So legal knowledge badly conveyed is better than the lack of legal knowledge conveyed in a presentable manner. By legal acumen, I would say it is largely an innate ability. It's something that you're born with, but it can be worked upon and honed and improved. Loosely speaking, legal acumen refers to the ability to quickly grasp legal concepts. It's important to remember that the legal concepts are often rooted in common sense. And then it refers to the ability to display keen insight and shrewdness. These are the qualities of which one would usually fit into having legal acumen. Next up, I feel the second necessary skill or trait that an advocate must possess is that of research. Now, the point to note is that although it is a common law jurisdiction, Pakistan also has a lot of written statutes. The number of these laws goes into the thousands. And you have federal laws, you have provincial laws, you have local laws, you have sub-statute legislation such as rules and regulations, and you have notifications and circulars. Besides all these laws, you also have pronouncements thereupon, and as per Articles 189 and 201 of the Constitution, respectively, case law decided by the Supreme Court and the High Courts have presidential binding value on subordinate courts. So, on top of all these laws, you have 75 years worth of judicial pronouncements, and not most of the laws, but like quite a few laws that are in effect today predate 1947. So you have judicial pronouncements spanning well over 100 years in some cases. So the point of all this is to drive in the fact that it is not humanly possible for a person to know all of the law. And this is where research is very important. It is a fundamental skill that a lawyer must present. And I would put it like in terms that it is not as important to know what the law is as it is to know where to find it. So you're not supposed to have all of the law on your fingertips. You just need to know where to look. And that is something that can be worked upon. And you cannot act as a lawyer for a party if you don't know what the law relevant to the issue ahead of you is. The only way to find out what that law is, obviously, is only through research. If a client reaches out to you and you are unsure of the law which applies to the case, don't just go ahead and advise incorrectly while pretending to know what the law is. Just like take a breath, try and seek time, go through the brief, do research around it, build your legal opinion, and then get back to the client. Research is the building blocks or the foundation that you lay, and by doing research, by reading more laws and more cases and having them stored somewhere for easy referral, you can move forward in the profession. First impression cases or cases which do not have an equal earlier precedent are very rare, and you will in most cases be able to find precedents in identical facts or similar facts to the case that is in front of you, because you can make sense of this as well. In 75 years, it is very difficult to imagine that no one has been in the predicament that your client faces. In rare exceptions where that is the case, you can also use precedents from other countries, and although they're not binding, but they have persuasive value. But you'll be able to find something or the other which fits your case, and you should never approach a matter without having researched on it. The next trait or skill which I feel is very useful, not just useful, but like necessary, is the work ethic that you must instill in yourself. Because when it is done right and when you do justice to the work that you're doing, advocacy is a very difficult profession because it requires a lot of work, focus, attention, discipline, and time. Time also. And it must be kept in mind that the work that you're doing, it affects people in more ways than one. Like every case that comes in front of you, without exception, the life, liberty, property, or some valuable right of your client is involved. So you have to make sure to give the matter its due weight. You have to be aware of what is at stake, and you have to do that irrespective of how much you have charged for the work, because you take the client's problem as your own, and then you like safeguard his interests or rights. That is how you must approach each case. The reading habit is must. That also requires a lot of time and energy, and you'll be expected to read a lot, and you will be expected to read almost every day. And because the reason that I've put this under work ethic as opposed to research is because most of the time you will find that you read through hundreds and hundreds of pages, and this exercise is undertaken only to find a few lines which may be relevant to you. So not only do you spend a lot of energy doing like reading stuff which you may not even end up using, it's very important to learn to skim read. And that should be done in a manner which ensures that once you get to the parts that are relevant to you, you do not skip over them, which are otherwise obscured within what you are reading. You may you have to like have an idea of what you're reading without knowing exactly what you're reading, so that once something relevant to you props up, you can read that part in detail. The next point that I would make is that focus required for an advocate is a double-edged sword, in the sense that while working on the case, you must at the same time and simultaneously keep in mind the bigger picture. So you need to have the ability to zoom out and look at things from the eagle's point of view and look at the big picture of what you're doing and what you're trying to achieve. And at the same time, you must also switch the other way and have the ability to zoom in and focus on the semantics of what you're reading, right down to commas and full stops and semicolons, because sometimes that is what the arguments turn on. As an anecdote, I argued a case where I had to differentiate between a loan restructured and a restructured loan, a restructured amount and an amount restructured. So the whole argument was premised on the fact that restructured before amount is different from restructured after amount. So these are some of the arguments that you have to make while arguing. So you have to do both. Next necessary skill which an advocate must possess is presentation. And presentation does not in this context note PowerPoint presentations. As you can see, I really do not excel in those. By presentation, I mean that an advocate must be able to present their work neatly and in a manner that gets the point across in the manner intended. And this is very important. You may be able to get your point across to the other side, but it may be received differently. So you have to ensure that it is received in the manner that you intended. And that is why you have to be careful with the way that you present it. And this applies to both the advice that you give to the client as it does to your oral submissions before the court, so that you are clear in what you want to say. And sometimes when you're acquainted with the file for a long time, you just presume things. And when you argue, you forget or don't keep in mind that the other person is not as acquainted with the work as you are. So you have to assume that they know nothing. And then from that, you have to structure your sentences in a way which gets them to where you are. So this is why presentation is very important. And obviously, if your oratory skills and convincing skills are good, that is very important. But as with the command of languages, that is not all. You also have to know how and when to use them, and to what extent you have to use them. And that ties in with the next part, that you have, when presenting something, you always have to be aware of and mindful of who you are presenting before, what stage of proceedings you are, what the setting of the conversation is or the argument is. And the last point is, like, I would say, important, because I feel it is something which is lacking in a lot of lawyers in Pakistan. They don't have proper grasp of the setting that they are presenting or arguing their case in, and sometimes they would say things which would be right, but like not at the right time. And this is something that I will come back to in the later part of the presentation. The next skill that I would highlight, which is necessary, is patience. Patience is, I think, more relevant to lawyers in Pakistan than it is to lawyers elsewhere. And the reason for this is that the profession itself is a very slow burning one. You not get good at it only through your hard work. Other factors also matter, because you can be an excellent lawyer, very able learner, quick grasper of concepts, but work might not come in at your way. You might not deal with work, and unless you deal with work, you cannot contextualize the law. That is something that I've learned from my experience. When you're studying law as a student, it's very different from when you're actually practicing the law. So you can only excel at the work that comes your way. And what work comes in your way is not in your hands. So therefore, it takes time before you get the required amount of work, the volume of work which goes through your hands, before you get the hang of what the profession entails and demands. In the long run, patience is key to being successful as an advocate in Pakistan. And even in monetary terms, I would say, unfortunately, young lawyers in Pakistan struggle to make living wages at the start of their careers. So you have to be patient in that sense as well. And the collateral of this fact is that a lot of competent lawyers who do not have the privilege of affording to make little money early on, such as those people who have financial responsibilities upon them from a young age, they end up leaving the profession in search of better income. So we lose a lot of brilliant people to this fact, due to this fact. And this is a harsh reality of the practice in Pakistan and advocacy in Pakistan. And I feel that employers and law firms must do something to correct this. And one of the ways to do that is by ditching the small chamber model and actually joining hands to make firms which would collectively generate more revenue, which could be shared forwards. Uh, Next point, I would say that in the short, another reason why patience is required is because in the short term, there is no concrete way of gauging the progress that you are making. In other jobs, you have fixed nomenclatures and you assign nomenclatures as you progress. But in this profession, there's no such thing unless you're working at a handful of firms, I would say. So you won't start off as a management trainee and then move on to assistant sales manager and then general manager or executive. You're an advocate and an advocate high court and you just stuck with that nomenclature. So there's no measurement of the progress that you're making. And this is something which means that there's a lack of motivation in continuing with the profession because promotion is a motivator, but you're not promoted per se when you're a lawyer. You have to assess that for yourself, and you have to since this source does not provide motivation to continue with the profession, you have to get that motivation from somewhere else. All you can do in the meantime is just to acquire the tools necessary, which are necessary to build a successful lawyer and hope that your time also comes. And in the shorter term, still from day to day for day to day work, especially for those of you who want to go into litigation or are doing litigation, it is very common to spend the whole day in court from say 8 a.m. to 4 p.m. only for your case to be left over for the other side to come and seek an adjournment at the end of the day. And your entire day and energy is wasted. So it is something that you must prepare yourself for, that your time utilization in this profession will be very inefficient, and that may lead to frustration. Because you'll have your patience tested on a daily basis and you just have to deal with this patiently in all three time frames. Right, next, moving on. Now we move on to the stages of advocacy and how different facets of your advocacy are engaged during different stages. The first step, it's not even the first step, it's just that the stage, the non-contentious stage where a dispute has not arisen and the client only comes through your door with the purpose of having an agreement drafted or of seeking an opinion with respect to some regulatory or compliance framework. But even in that stage, you are still an advocate and you're advocating the cause of the client. You must always be mindful of the best interest of the client. And while you're drafting these non-contentious documents or advising thereupon, you must always be aware of the relevant laws. That is not something which you should leave for the dispute stage. You should always cater for them at this stage when you're drafting the documents. You should be aware of the relevant laws that may be attracted to that agreement and all the pronouncements thereupon. And you have to ensure that you protect the rights and remedies of your client, like you safeguard them in the non-contentious document. And the way to do that is that while it may not come to that stage eventually, but you should always draft each provision like it will be scrutinized, every word, every sentence, every comma, and argued upon in court. You have to ensure that you draft it in a way, in the manner which, again, furthers the interest of your client. You have to understand what the client wishes to achieve, and then you have to plan as to how the desired income can be achieved. And all of this you have to do while ensuring that you remain within the bounds of the law. And you should then draft an agreement which you are sure will be enforced by the court if and when required. Now we go to the contentious stage of advocacy, or should I say contentious stages. I have subdivided these stages into separate parts. First stage I would like to talk about is the pre-filing stage. So when the client comes in with the contentious matter, the first thing that you need to do is to pinpoint and locate the appropriate and attainable remedy for your client. And if multiple options or remedies are available with you, you should discuss them with the client and chart a course of action and decide which one to embark upon. Once remedy is decided, then you have to choose the appropriate forum from which the said remedy that you have decided is to be sought. And there is nothing more embarrassing than to have your claim dismissed due to non-maintainability. And if your claim is, and by you I mean your client, if it is dismissed for non-maintainability, most of the time the blame would lie on the lawyer. So as an advocate, you must ensure that it never comes to this stage. Then before filing, you also have to check the laws and see if there is any mandatory requirement to issue notices, legal notices. And if there is, you fulfill that. If not, then you can still opt to send a legal notice, because you always want to avoid going to courts for the sake of the client, not for your own sake, I would add, and get the dispute resolved out of court. So one way of ensuring that is to send a legal notice and see what sort of response it prompts. And once it is decided, the adjudicating forum is decided which you intend to approach, or in cases when you're defending the matter and the matter has already been initiated and you're putting up a defense. Probably the most important tool of advocacy today, as it is, comes into play, and that is the drafting of pleadings. So it is, at this stage, it is important to remember that you cannot travel beyond your pleadings. So when you draft your pleadings, that is the entire case that you set up, and which you will be required to prove through evidence and supplement with arguments. The easy option would be to get a previous draft and fit your case into the said draft. However, that would be the wrong option. The proper way to draft your pleadings would be to get acquainted with the facts first and foremost, look up all of the law at this stage, fit the facts into the law, and then commence the drafting work. You should always remember to plead your facts in a way which support the interpretation of law as you want adjudicated from the adjudicating forums. So you should undertake all of the labor, I would say, at this stage. Most of the labor is to be undertaken at this stage when you're pleading, drafting your pleadings. And another benefit of this, of doing so, would be that this is the written version of your case, which will always remain available on the record of the file. And though the judge might not remember your oral arguments, but like your pleadings will always be available to the judge for him to or her to peruse at any given time. The form of pleadings, including the legal paragraphs that you have to include in the draft, must never be forgotten. You can find those in the statutes as appendices, or you can find them in books or a previous draft. The break clause is again very important. because you have to have clarity as to what you're seeking from the court, what you want from the court, and you have to ask for it in the gray clause. And at this detailed workshop on legal writing has already been conducted through this platform by Ms. Aisha Malik. And I think it is also available on YouTube. So that would be a useful tool for anyone who's interested to like go through and see, learn about legal writing in detail. Now, the first post-filing stage of advocacy is the initial hearing, which is the first hearing after you have filed. And the scope of this hearing must never be forgotten. It is not to get final relief. It is just to get your claim admitted for hearing or to obtain any temporary injunctive relief. And this hearing, most of the times, happens in the absence of the other party. And the temporary injunction part is not to be understated. It is very important sometimes because it prevents the rights of your client or the party that you're representing from being further adversely affected. It is not for you to convince the court that your case will succeed. It is just to convince the court that you have a case worth hearing and adjudicating upon. And that should be kept in mind when you are advancing your arguments. Mostly these arguments would touch the maintainability of the claim before the said forum and how the forum is competent to grant that relief eventually. Although these issues can also be raised by the other party in defense, but sometimes the court also raises them at the initial hearing. On a side note, unfortunately, as things are in Pakistan, this is sometimes all there is to a case because most cases are not filed to get their merits adjudicated upon. The main or the only purpose of the case is just to get a stay order, which they would drag on for sometimes years on end, just to frustrate the party and try to get them to come to some sort of an out of court settlement, or just like to frustrate them generally. So for the initial hearing, you must have the facts of the case on your fingertips. And the brief must be flagged and marked for reference to any documents that you have to use. Because the courts are dealing with the large volume of cases every day, they get easily frustrated if the lawyer who's appearing in front of them does not have his case prepared. So you have to make sure that you're well aware of the facts of the case and you can pinpoint any document as required by the court and have them readily referenced. And if your case is admitted, notices are sent to the other parties and replies are called from the other parties or the defendants. Any miscellaneous applications which relate to pre-trial stage are also adjudicated upon before the stage of evidence commences. And again, for these miscellaneous applications, it is again important to remember that you must keep yourself confined to the applications themselves and not to extend your arguments to the merits of the case, especially in cases where the miscellaneous application does not have any nexus with the merits of the case. Most of the time, what happens is that ad interim, which means the orders passed on the first date of hearing in the absence of the other party, or interim orders, which is decision which would hold till the final disposal of the case. These orders passed in miscellaneous applications are challenged before the higher forums. And sometimes such challenges go all the way up to the Supreme Court. And the matter before the original forum remains pending or stayed until these applications are decided upon by the higher courts. So it's possible that you may be stuck on this stage for a long time. And obviously, such applications can also come up after the commencement of evidence, but like the point of telling you, narrating all this is telling you that the pre-trial stage usually extends a long time, and that would bring me to the discussion of the next part, which is the trial part. Now, by trial, I refer to the process of fact finding or recording to evidence, if that falls within the scope of the adjudicating forum, because not all cases require the recording of evidence. For the high courts, for instance, in their original jurisdiction under Article 199 of the Constitution, which is known as the writ jurisdiction, they're not fact-finding forums, but they can only decide questions of law. And if there's any dispute as to the facts, the petitions are dismissed as not being maintainable. So evidence, the rules of evidence in Pakistan are contained in the Qanun-e-Shahadat order, and evidence may be documentary or oral, or in most cases, it's both. So what the rules of evidence dictate is that the person claiming, that the person who asserts a fact has to prove it. The onus is on whom, subject to some exceptions. And the way to do that is to produce witnesses and documents in relation thereof. Order of recording of evidence is that the person who asserts the fact, or the person claiming, he goes first. The person who's filed the case, he has to go first, and he has to call his witnesses, and they give their evidence in their statements and tender the necessary documents in what is referred to as the examination in chief. What must be remembered is that no leading questions may be asked during examination in chief, and leading questions are questions which can be answered in yes or no. So if you want the party to tell you where they were at a certain time, you can't ask के हाँ जी आप इस दिन के उस वक्त उधर थे कि नहीं थे, या आप उस दिन उधर थे. You can only ask in a manner which is open-ended कि उस दिन आप कहाँ थे, so that the witness answers the question. But like as a side note, in litigation today, at least in Lahore, this examination in chief is made redundant because the lawyers dictate the entire thing, and the witnesses are just idly standing by while the lawyers are dictating examination in chief, which is not permissible, but it's happening and there's no check to it. Once the examination in chief has been recorded, the opposing party gets the right to cross-examine the said evidence. And the purpose of cross-examination is to dent the case of the opposing party. In times gone by, or like in folklore of law, sometimes the lawyer's competence was solely judged by their ability to cross-examine. Today, however, a lot of competent lawyers, even those who are actively litigators in Pakistan, they're not interested in trial work as much. So the litmus test for a lawyer has moved on from just the ability to be able to cross-examine. And I would advise all young lawyers and students, especially those who want to partake in litigation, to get experience in trial work. It's very important tool to have the ability to know how to cross-examine or how to determine the facts. And for cross-examination, leading questions are not only permitted, but I would advise that you only use leading questions while preempting the answer. So you only frame your question in a manner that you know will be answered in a yes or no. And ideally, you should know if the answer would be yes or no. While bearing in mind the purpose is to dent the testimony that has been given. After cross-examination, the parties whose witnesses have been subjected to cross-examination, they have the option to offer evidence and rebuttal. However, the scope is very limited in nature, and then the process repeats for the other party, the defense party. A few words on evidence stage, that although it's straightforward in theory, the actual process of recording evidence in Pakistan is extremely problematic. For starters, the stage of evidence, especially if you're doing civil litigation, comes years and years after filing the case in most of them. Because the dispute is not fresh in the mind of the witnesses or the lawyers, so this process becomes a bit more complicated. And then further, the task of ensuring that the adjudicating officer, all witnesses of the parties, counsel for the parties are all present. That is a monumental task. And someone or the other is absent, usually absent. And even once you get to that stage of recording of evidence, actual recording of evidence takes place after further delay, sometimes extending into years. Another practice which is started in the courts, which must be frowned upon, is the recording of evidence through local commissions. Now, local commissions are lawyers who are appointed by the courts to record evidence. And the judges themselves do not record the evidence. And by indulging in this practice, some of the very important parts of evidence recording are ignored, because as per the law, the judges are expected to note the body language of the witnesses, and they're supposed to moderate the line of questioning, and they're supposed to decide upon the objections. So when the local commission is deciding, recording your evidence, these things go unchecked. So, contrary to cinema and common folklore, objection, my lord, नहीं होती, क्योंकि my lord ना रिकॉर्ड कर रहा होता है एविडेंस, ना वो लोकल कमीशन जो है उसको समझ आनी है इस चीज़ की, तो आप ऑब्जेक्ट कर भी दो किसी चीज़ को, तो वो सिर्फ उस पर लिख देते हैं कि जी यहाँ पे ऑब्जेक्शन आ गई है एंड विल बी डिसाइडेड ड्यूरिंग फाइनल आर्गुमेंट्स. तो जो स्टीरियोटाइप आपकी वकालत का एक फिक्र है वो आपको यूज करने को नहीं मिलेगा once you're actually in practice. Now, the final hearing stage of what facets of advocacy are required at the final hearing stage. Once the replies have been filed and the evidence is recorded, or where no evidence is to be recorded, the matter goes to final arguments. And it is not uncommon that final arguments are made before a judge who wasn't even involved in any of the prior stages of the case, including recording of evidence. Someone else recorded gave the initial hearing. Your case got transferred to another judge, then to another judge. One judge part recorded your evidence, the other judge part recorded your evidence, and then it is transferred to someone else at the time of the final hearing, and you have to argue the case from scratch. The way to approach final arguments is to give the summary of your entire case, all facts that you have pleaded, all documents and statements which you have produced to support your facts, all the laws and pronouncements relevant to your case which support your interpretation of the law and its applicability to the facts of the case. All of these are stated during final arguments. And as we saw earlier, at one time, this was the entirety of advocacy. And even till this day, it remains an important part of advocacy, and one which every lawyer, at least every litigation lawyer, must work at. If your facts are strong, argue the facts. If your legal position is strong, argue the law. If you feel that uh, in deciding the case while following the law, the outcome would not necessarily be just, argue passionately about the injustice that you think will manifest from that decision. And you must remember that judges are also humans. And if you can't appeal to their legal side, try and appeal to their human side. And you can take liberty with the emotive elements of your arguments during final arguments. It is always advisable to give written skeleton arguments at the conclusion of the final oral arguments. Again, this ties in with the earlier point that I was making, insofar that the written version can be referred to by the judge at their will, and that will be the version which will be in your language. So while you're arguing orally, and even if the judge is noting down your argument, sometimes the meaning will get lost in the paraphrasing when the judge is noting that down in his own words or her own words. By submitting written arguments, you ensure that your exact choice of words is available with the judge when they're deciding the case, and the exact manner in which you want to make an argument or convey a point is available with the judge when deciding the case. Finally, we reach the post-decision stage of contentious matters in advocacy. And it's important to remember that even if your case is decided, that is still not the end of your advocacy for that brief. In cases that are decided in your favor, the next step is to get the decision implemented. And in some cases, that is done by initiating separate proceedings, which are known as execution proceedings or execution of decree proceedings. And those are meant to satisfy and enforce the decree passed by the court. Now, the execution process again is very hard and tedious, especially when recovery of money, unsecured recovery of money, is involved. And as far back as 1872, the Privy Council had observed that the difficulties of the litigant in India begin when he has obtained a decree. And unfortunately, after a lapse of about 150 years, not much has changed. Other ways to implement the decision is by filing contempt in case of non-compliance. This is done if for injunctive orders or directory cases where the court has ordered someone to do something and they do not do something, and they don't comply with the decision, you can reapproach the court and file contempt and let the law take its course in that way. Similarly, if the decision is made in arbitration or other quasi judicial forums, then they have to be made the rule of the court first before they can be implemented, and you have to trigger the mechanism of ensuring that they become rule of the court so that they can be enforced later on. And moving on to cases where the decision is not in your favor, you have to decide upon the next step, and that next step may involve challenging those decisions so rendered before higher forums. And in some cases, you might have to make the call as to whether further litigation would be fruitful at all or not. And orders and judgments, depending on their nature and forum which pass them, can be challenged in various ways. So it is important to know which remedy to avail from which forum, and you have to be sure of that before challenging the decision that you want to challenge. And again, for appellate proceedings, besides what we discussed in the original proceedings, you must be acquainted with the proceedings that took place in the forums below, which culminated into you invoking the appellate forum. And sometimes the appellate proceedings can go longer than the original proceedings. And it may be remembered that these appellate proceedings may also be happening on miscellaneous applications all the while your original matter is pending or stayed. But after the final decision, again you may engage in an appellate procedure and go through 2 or 3 forums again. And sometimes it so happens that the way that the appellate proceedings end is that the matter is remanded back to the first forum again. So you're back to square one and you have to redo everything again. Okay, now we move on to the next section of this workshop, which is advocacy in practice and how it differs due to different I would say conditions or different circumstances. So advocacy in practice would differ due to different areas of law, and civil practice would be different from criminal practice, which is different from constitutional practice, which is different from practice in special laws, and so on. And while it is not advisable to restrict yourself to a specific field or a specific area of law too early in your career, you may find that you excel at certain areas of law more than others. And the primary reason for this is that different facets or aspects of advocacy are more relevant to certain areas of law than to others. What this means is that not all areas demand the same type of advocacy or the same level of advocacy. For example, if you practice civil law, the turnover and decision time for cases is far greater than that for criminal law. A criminal trial is concluded relatively early in most cases as opposed to civil cases. So if you're a civil lawyer, you will find that you have to wait much longer for a case to be concluded than your criminal law practitioners counterparts would find. And that would mean that criminal law practitioners would be more acquainted with and more experienced in trial work than their civil law counterparts if both these lawyers spend the same amount of time in the profession. Similarly, criminal law would be very fact intensive as opposed to civil law. And the law is more or less settled in most cases, but the decision would turn on the basis of that exact fact pattern. And for criminal lawyers, especially then, cross-examination becomes much more important. Usually in civil cases, we have documents to support claims. There's a pre-existing relationship between the parties or something or the other. In civil cases, in criminal cases, I beg your pardon, that is not the case. And mostly the story is narrated on account of ocular or ocular evidence or eyewitnesses accounts. Although in some cases CCTV footage may be available or a video may be available, but mostly it's ocular evidence, and you have to discredit the version or support the version that whichever suits you. Civil law practice, on the other hand, is quite different because the procedures are not very burdensome, but like I would say civil law practice in Pakistan revolves around the interpretation of procedural law much more than it does in criminal law. And if one was to look at the judgments on civil law, one would find that judgments on the procedure far outweigh the judgments on substantial law. It seems like as a society, we got fixated on the procedural law and like it never came, or it really came to the fact where the substantive law was an issue or was to be decided. Mr. अब अगर आपको थोड़ा सा आइडिया है पहले से, तो आपको पता होगा कि रिटन स्टेटमेंट से पहले 7-11 जाती थी, चाहे बनती हो या ना बनती हो। इसी तरह स्टे एप्लीकेशन होती हैं, उसी पे सारा केस आपका होता है। एक्चुअल तो रेमेडी कम लोग सिविल लॉ में सीख करने जाते हैं। Similarly, moving on, constitutional matters जो हैं वो those are entirely different because you need a lot of academic research and references to international law and foreign jurisdictions. So practice of constitutional law is entirely different from practice of any other field. And more and more people are now limiting themselves to this area of law because वो एक तो it starts in the High Court or the Supreme Court. So like people who are uncomfortable with trial work don't want to go to the lower courts. They choose this route. And similarly now, because there's a lot of special laws in force for specialized fields, there'll be a lot of going forward. There'll be an increased demand of specialist lawyers as well, and there's been an increased trend towards enacting special laws for different areas. So we have a lot of specialized laws in Pakistan now. These are related to banking, companies, financial white-collar crimes, electronic crimes, insurance matters, tax, intellectual property, labor, family, and people might limit themselves to these special laws. That is also an option, and I think it has a lot of scope going forward because specialist lawyers would be the need of the future, and I would argue so would specialist judges. But that's something which we will see how it pans out in the future. So for special law practice, the difference is that usually the special laws have their own courts or tribunals or forums of first instance, and then they have their own appellate hierarchy. And special law is different because it is largely self-contained. So you do not need to make references to multiple laws for, say, procedure, another law for substance, another for limitation, another for appeals, as all those things are usually catered for in the relevant statutes and rules. So your experience with advocacy will differ depending on which area of law you choose to practice in. Moving on, it will also, within areas of law, differ on the basis of the forums that you're appearing before. So, as I said in the earlier part of this workshop, that you must always be mindful and aware of who you are appearing before and presenting to. When you appear before the lower courts, it is my experience that you have to approach your arguments slightly differently than you would if you were to approach the higher courts. And I found that sometimes intricate interpretations or novel interpretations of laws and arguments may not be appreciated as much by the lower forums. And that is not to say that you should not try to do it. It means that in case you feel that the lower court is resisting that or not appreciating the point that you're trying to make, you should have the ability to recalibrate in case things are going south or aren't going as you want them to. And anecdotally, from personal experience, it once happened that I was arguing before a civil judge, and when I tried to argue an intricate point to argue very can say a fine point of law, he completely lost track of what I was saying and stopped me middle of the argument and said, "Counsel ji, chhaddo na, moti moti gal dasso." And मतलब मैंने सोचा तो यही कि भाई मोटी मोटी गाल दसनी होती तो मेरा क्या काम था यहाँ पे, मैं तो आपको बताया ही कोई फाइनेंस की बात हूँ, लेकिन फिर you recalibrate midway and you require to hold the hand of the judge, पकड़ के उसको लेके चलते हो स्टेप जी, ए ये है, बी ये है, सी ये है, और साथ साथ you have to make sure कि the judge is also following what you are saying, क्योंकि you will find कि in the lower court sometimes जो judges आपके सामने सुन रहे होते हैं matter, they don't ask many questions. So there's no way of knowing what's going on in their minds, if they're following what you're saying or not. And that is why it is upon you as an advocate to just stop and preempt any confusion or ascertain if there's any confusion in the judge's mind, and then endeavor to clear it by asking the judge के ठीक है, समझ जा रही है, ये आप फॉलो कर रहे हैं बात, कोई क्वेश्चन है तो पूछ लें मेरे से. Because what happens is if you don't do it, he will just listen or she will just listen to your entire case, not speak a word, write down something, and the order goes against you, and you find कि जो आपकी रिप्रोड्यूस हुई हैं आर्गुमेंट्स वो तो बिल्कुल ही डिफरेंट तरह हो गई हैं, या एक ऐसी चीज पे कर दिया जो उसने पूछा ही नहीं, आपको कन्फ्रंट ही नहीं कराया. You have to be a bit more proactive while arguing before the lower courts. Before the higher courts, the main issue would be paucity of time. आपके पास इतना टाइम नहीं होता कि आप लंबे आर्गुमेंट्स करो, स्पेशली फॉर जूनियर लॉयर्स या इफ नॉट समवन जिसका कोई नाम या चेहरा है, फिर तो आपको बिल्कुल भी ज़्यादा टाइम नहीं देता ना देते कोई भी जजेस, क्योंकि उनकी कॉज लिस्ट इज लाइक 60-70 cases. They have limited amount of time. They have to then write the orders for those cases. So they just want you to be quick. And खुद से भी they try to expedite the process. एक तो if they've read your file, there'll be a lot of cross questioning, which as I was saying कि नीचे तो ये डिसएडवांटेज होती है, ऊपर जो है वो एडवांटेज ये है कि वो आपसे क्रॉस क्वेश्चनिंग क्या करते हैं, लेकिन द डिसएडवांटेज विद दैट इज कि आपका फ्लो नहीं उस तरह से बनता आर्गुमेंट्स का. So a good advocate must be able to answer all those questions without losing that flow and sight of his own line of arguments, and answer those questions consistent with what you are arguing otherwise. That is something that you develop by regularly appearing and arguing, to just handle that distraction एक तरह से, and like also distraction भी, लेकिन challenge to your arguments from an angle which you might not have considered. And it is very important that you, while preparing your arguments, also think पहले से कि जी इस तरह भी कोई पूछ सकता है, इस तरह भी पूछ सकता है साइडों से, and you must be aware and you must have an answer ready. Yeah, if you're not, you must be quick on your feet and like making connections and just arguing something or replying with something which does not destroy the case that you're arguing. And for special courts or forums or tribunals under special laws, because a lot of cases, because the cases are repeated, oft repeated, or run एक ही तरह के ज़्यादातर देख रहे होते हैं, तो जो adjudicating officers, the ones who are sitting listening to your cases, they're relatively better versed unless they're new with the laws that they're dealing with. अगर तो आपका case falls in the category of a routine case, that is a benefit. But if you have a case which is slightly different from the run of the mill, so the challenge that you face is to sometimes find it difficult to convince the judge that my case is different from what you are used to, or their first attempt will always be to fit your case into what they already know. So it's important to be able to know how to convince the judge to step outside their comfort zone and just look at it from where you're coming from. Lastly, I would say that advocacy differs in practice due to difference in judges. It is a well-known saying, know thy judge, know the judge that you're arguing for, and that is true for Pakistan as well, because not every judge is the same. And it is very important that you get an idea about the judge that you're appearing before or supposed to appear before. And you can, like, on a side note, in foreign jurisdictions, you will find that judges have clear identifiable ideologies. You could say this judge is a literalist, this one is a contextualist, this one is conservative, this one is more liberal. So in Pakistan, barring some few notable exceptions, you don't have that consistency in the ideology of judges. And even from the side of the bar and academia, there's been little to no attempt to try and ascertain this fact as to whether judges have clear ideologies or not. And the metric which has been deployed by lawyers in assessing judges is जी ये relief giving है, जी ये वाला relief giving नहीं है. Now I would say कि relief giving जो है ये कोई इतना अच्छा metric तो नहीं. It's not a particularly good metric because nor should it be a criteria of assessment, because not every brief deserves automatic relief. और ये कि जी लीव नहीं भी बनता तो जी दे देते और फिर बाद में डिसमिस कर देते, आई डू नॉट एग्री विद दैट. आपका ब्रीफ पे ही होना चाहिए. बट लाइक जजेस को भी चाहिए कि आप उनकी कर लें थोड़ी सी, मतलब कंसिस्टेंट रह रहे हैं अपनी आइडियोलॉजीज में. आपने अगर लिटरल इंटरप्रिटेशंस लेनी है उसी से स्टिक करें, अगर आपने कॉन्टेक्चुअल इंटरप्रिटेशंस लेनी है उसी पे रहें, अगर आप लिबरल किसी चीज को कंस्ट्रू करना चाहते हो उसी पे, अगर आप कंजर्वेटिवली करना चाहते हो आप उसी पे रहा करो और फ्लक्चुएट ना किया करो फ्रॉम केस टू केस, बिकॉज दैट इज that takes the certainty out of the law, and law is built upon the idea of certainty. For High Court and Supreme Court judges, the way to prepare for what to expect in the judge is to go through their judgments which they have authored. उससे आपको थोड़ा सा आइडिया हो जाएगा कि वो ज़्यादा काम एक किस फील्ड में कर रहे हैं और किस तरह की जजमेंट्स हैं, और एकेडमिक ज़्यादा हैं, ज़रा उस तरह के हैं जो डिसीजन से ज़्यादा प्रेफर करते हैं कि डिस्प्यूट किसी और तरह सॉल्व हुए, जो प्रोसीजर पे ज़्यादा फिक्सेटेड होते हैं कि मैरिज पे ज़्यादा करते हैं कोशिश करने की. जस्ट गेट एन आइडिया. या इफ़ यू कांट डू दैट, like no, if you can't do that for lower court judges, so you can go and sit in their courtroom एक दिन पहले या आधा को घंटा एक गुजार के देखें in their courtrooms, just to see how they conduct court proceedings. Do they give the counsel more time to argue? Are they quick? Are they engaging with the counsel or not? Just to prepare yourself and know कि जब you will go there to argue your case, what will you face वहाँ पे. And this can also be done with High Court and Supreme Court judges. कि आप वैसे just go and attend their courts. So it's a good idea to do that, just to prepare yourself for that specific judge. Now I'll just conclude my workshop and open the floor to questions. But before that, I wanted to give some final thoughts on how advocates who are going to join the profession or just join the profession, what they can do to ensure there's some improvement in the system. And as you all know, it's been widely publicized and everyone knows that the current justice system, it is heavily burdened with pending cases. And I feel personally that lawyers can do a lot of, lawyers hold a lot of power to reduce the backlog. And the reason I say that is because courts का आप कहते हो कि they don't work, but like अगर पूरा दिन आप गुजारो किसी भी के कोर्ट रूम में, you will find कि out of 60 cases, 45 या 50 में one or the other party is seeking an adjournment. और the court liberally दे भी देती है, कभी कभार नहीं भी देती, but point is कि if the lawyers are prepared, if they're willing to argue the case, I've seen civil disputes, civil cases being wrapped up in a matter of months. So when the will is there, so everything can be done. But the problem that we face is that the will isn't there. And the clients who have a genuine dispute, who want resolution of their disputes, avoid going to courts. क्योंकि स्टिग्मा ये है कि जी फंस जाएंगे, उलझ जाएंगे, फंसा रहेगा केस, दे से कि अच्छा जी कोर्ट नहीं जाते, कोई और आउट ऑफ कोर्ट सेटलमेंट या ADR arbitration mediation में चले जाते हैं just to avoid the delays. And 90% of the time, the party which does approach the court, yeah, one of the parties, either the defending party or the party that goes to court, उसके लिए beneficial है to delay the case. क्योंकि जी stay लिया हुआ है या तंग कर रहे हैं, जो भी issue है वो they will try to drag it on as much as they can. And I feel कि if lawyers decide कि हमने इस तरह की केसेस जो हमें पता है कि they are frivolous in nature, arm twisting वाले हैं, even as per the rules under which we must operate, एक तो इनफ्लो बहुत कम हो जाएगा कोर्ट्स में, जेन्युइन डिस्प्यूट्स होंगे, प्रैक्टिस बेहतर होएगी. आप जब क्लाइंट आपके पास आते हैं, आप उसको एडवाइस करो कि यार ये ना करो, या लॉ इस तरह है, तुम्हें कोई फायदा नहीं है, ये सही तरीका नहीं है कि तुम किसी को तंग करो या स्टे करो, तो फिर वी कैन सी इम्प्रूवमेंट्स इन द करंट लीगल सिस्टम. और इन दैट रिगार्ड आई थिंक सुप्रीम कोर्ट ने भी रिसेंटली भी कहा है कि दे विल इम्पोज कॉस्ट्स, बिगिन इम्पोजिंग कॉस्ट्स ऑफ द केस, व्हिच इज आई थिंक अ गुड आइडिया. कि दो दफा सोचेंगे तो सारे ना कि जी ये जानने डिसमिस हो गया तो कॉस्ट पड़ेगी, दूसरी पार्टी को पूरी कॉस्ट देनी पड़नी है. तो दैट इज वन वे, बट लाइक एज लॉयर्स वी कैन डू अ लॉट मोर टू इंश्योर कि जी ये ना हो. एंड अगर कुछ लॉयर्स या स्मॉल माइनॉरिटी ऑफ लॉयर्स डिसाइड टू डू दिस, दैट इज ऑफ नो यूज. मैं अगर केस यूज करता हूँ कि नहीं जी आपका तो फ्रिवलेस केस है, मैंने नहीं करना, अगले मिनट he can go and name 10 lawyers who are willing to do that case. So it will only work if we collectively decide not to do this, and just like discharge our duties in a manner that we advise the client honestly and sincerely, and just tell them not to abuse the process of law, not to file cases just for the sake of it, and just like guide them properly. तो I feel कि काफी चीजें बेहतर होने का इसमें है स्कोप. सिर्फ लॉयर्स के एटीट्यूड से काफी बेहतर हो जाएंगी चीजें. एंड कंक्लूडिंग रिमार्क में यही दूंगा कि यंग लॉयर्स एंड लॉ स्टूडेंट्स आर द फ्यूचर ऑफ दिस प्रोफेशन, एंड वी मस्ट इंट्रोस्पेक्ट as a whole and embark upon a course correction. And we must remember that this profession is an honor, and it should be given its due. And with that, I would conclude and thank you all and open the floor to questions that you may have. And I think Zarak will be taking questions and moderating them.
If anyone has any questions, please send them in the chat and then I'll forward them. So we have a question from Noor Fatma. It's how can we talk to the most marginalized communities and engage them on their legal rights?
That is a good question. For the most marginalized communities, it is important to remember that they do not have access to us. So we'll have to go seek them out. And we can do this by setting up workshops. We can do this by setting up wings of an organization whereby the sole task is to reach out to those people and just have educational seminars, just invite them and ask them about their problems and advise them as to any possible legal remedy that may help their cause. So, briefly, I think the answer to this question is that we have to seek them out, and we can't wait for them to seek us. there's some funding available if someone wishes to embark upon that project, whereby you can set up something which is engaged in this sort of practice.
I have another question from Ahmad. They're asking about, they're saying essentially a lot of times what happens is that there are personal relationships that people have with the judges when they're in the courtroom. So what if you're on the opposite side of that, where you can clearly see an inclination of the judge towards your opposing counsel? So how do you navigate something like that in the courtroom?
This also ties in with various other problems that we have. So, as an advocate, when the client comes to you and says, this is my problem, kya karu? Do you tell them कि ये करें, and then you say कि we will try our best to do this, and then we will see what happens. Lekin there's some lawyers in the market now, unfortunately, जो clients कहते हैं कि फिक्र ही ना करें, हो जाएगा. अब ये जो कहते हैं कि हो जाएगा, उसमें वो जी कट मांग लेते हैं कि जी इतना जज को जाएगा, इतना आप मुझे दें, मैं आगे मैनेज कर लूंगा. एंड देन दे आल्सो से कि जी हम जज को मैनेज कर लेंगे. एक तो वो आपकी इरोड करता है परसेप्शन ऑफ द जस्टिस सिस्टम. फिर समटाइम्स यू फाइंड कि वो सिर्फ इंप्रेशन ये दे रहे होते हैं, दे डोंट एक्चुअली हैव एक्सेस टू द जज, बट अदर टाइम्स दे डू हैव एक्सेस टू द जज. और स्पेशली जो ओहदेदारान आप कह लो हैं, वो तो पाई चेंबर्स में जाते हैं कभी कभार जिसके उसमें हाउ यू नेविगेट इज दैट यू ट्राई टू डील विद इट उधर ही, इन द सेंस कि यू इंसिस्ट कि जो भी हियरिंग हो ओपन हियरिंग हो, सारों के सामने हो, चेंबर से फाइल ना जाए, यू फॉलो अप ऑन द केस कंसिस्टेंटली, यू कीप एन आई ऑन इट. अगर चीज़ें मैनेज नहीं हो रही तो दो तीन तरीके होते हैं. एक, आप ट्रांसफर एप्लीकेशन दे सकते हैं कि जी मेरा केस किसी और जज के पास चला जाए, दैट विल बी जुडिकेटेड अपॉन द बाय द डिस्ट्रिक्ट जज. आई हैव नेवर डन दैट. मैं तो उसकी कॉन्शियंस को थोड़ा हिट करने की कोशिश करता हूँ उम्मीद से कि जी करवाना आप ही से, चाहे आप जो मर्जी कर दें, लेकिन उम्मीद ये है कि आप कोई सही चीज़ ही करेंगे, अपने ज़मीर के मुताबिक करेंगे, नॉट बिकॉज यू बीन अप्रोच्ड. या आप जज से कहते हो कि यू मेक रेफरेंस फॉर ट्रांसफर ऑफ दिस केस. अब उस तरह ये होता है कि केस किसी और के पास चला जाता है बिकॉज द जज रिफ्यूजेस टू हियर इट. लेकिन इशू ये है कि ये भी ना, जो ट्रांसफर वाला है वो लॉयर्स ने मिसयूज करना शुरू कर दिया कि जी स्टे बहस करवाने चाह रहे हैं जज साहब, तो जी मौके हो रहे हैं, आखिरी मौका हो गया है, कतई आखिरी मौका हो गया है, हतमी कतई आखिरी मौका हो गया है, जुर्माने के साथ हो गया जी फाइन, और आखिरी डेट पे वो आके कहता है मुझे जी कोर्ट पे ट्रस्ट नहीं है, रेफरेंस भेज दें. तो डिस्ट्रिक्ट जज को पता उसको भी अब पता लगता है कि भाई इस तरह के भी आ रहे हैं, तो वो भी फिर ट्रांसफर नहीं करता, लेकिन कभी कभार भी देता है. या फिर आप उस फोरम से उम्मीद हार लें और ये याद रखें कि इसकी अपील है, ऊपर भी जाना है इसने, ऊपर वाले फोरम पे जाके ये करेक्ट कर लें, जो कि क्लाइंट को इट विल कॉस्ट यू, लेकिन इट इज समथिंग दैट वी हैव टू डील विद, अनफॉर्चुनेटली.
I think that's all the questions we have today. Thank you so much, Ahmad, for being with us today, for taking out time. And I'm sure this is extremely useful for all our participants as well.
Thank you for having me at this forum, and keep up the good work that you're doing, and thank you for the audience. Allah Hafiz.
Thank you.